In this video, we take a look at intellectual property protection. So let's start by defining the term. The definition here is provided by the World Intellectual Property Organization, which is set up by the United Nations. Intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Intellectual property itself is backed up and protected in law by a number of different mechanisms, and 4 of them you have to be aware of for the exam, and they're the concepts of copyright, patents, trademarks and licensing. Let's have a look at those in a bit more detail now. So these methods of intellectual property protection enable people to 1. Earn recognition or financial benefit from what they invent or create, and 2. Prevent others from benefiting financially or otherwise from someone else's invention or creation without prior permission. So copyright is a legal term used to describe the rights a creator has over their own work. If you create an original work, you automatically own the copyright for it. It's not something you actually have to apply for or pay for. This can include books, music, paintings, sculptures, films, your own computer programs, databases, advertisements, maps, technical drawings, and much, much more, as long as it's an original work that you have created. Patents are a step further. They're an exclusive right granted for a particular invention. Once applied for and granted, a patent provides the patent owner with the rights to decide how or whether the invention can be used by others. A trademark is a sign which is capable of distinguishing the goods or services of one business from those of other businesses. Now, trademarks actually date back to ancient times when artisans used to actually put their signature or their mark on a product. And finally, there's the concept of licensing. Most commercial software comes with what's known as a license, and this is a legal agreement which outlines the use and the redistribution of the software. Now, it is possible for someone who produces software to put that into what's known as the public domain. Once you've done this, it is no longer covered by copyright and can't be licensed. The Copyright Designs and Patents Act is an example of a piece of legislation which has had to evolve in order to keep up with technology. Now, although it's not actually mentioned in your specification, it's worth knowing about in the context of this video. This act of legislation makes it illegal to copy any work without the owner or copyright holder's permission. In terms of technology, this relates to work such as digital files, images, or pieces of software. Now, obviously, owning the copyright doesn't actually stop others from copying it, but it does allow the owner to bring actions in the courts. So just to recap, if you pause the video and take some notes, we've covered here the various methods that can be used to protect intellectual property. One of the most well-known examples of open source versus proprietary software is the battle between Linux and Windows. Linux is an open source operating system and Windows is a proprietary operating system. In the early days of computing, programmers shared their code in order to learn from each other and involve the field of computer science. Eventually, this approach moved towards commercialization of software in the 1970s. Starting in February 1983, IBM adopted an object code only model for a growing list of their software and stopped shipping source code. Also in 1983, binary files became copyrightable in the United States as a result of the Apple versus Franklin law decision. Provided here is a summary of what we've just discussed on open source versus proprietary software. Pause the video and take some notes.